I've got an itch I can't scratch, I'm missing a piece that completes a whole part of me, an open wound scar to see. Everybody come here, gather round, welcome to the freak show, the best in town. What the hell's wrong with me? I don't get along with anybody, honestly. I've been living in my own head constantly, thoughts jumbled round, think I need a new lobotomy. Wait, all these thoughts are too negative. I don't wanna get lost in the sedative. Gotta show them what I got, I'm competitive. You know I'm about to go off, I won't let them win, I'll take a stab. I wanna chase the bag, I wanna weigh, I can change all the things I lack. I gotta face the facts, I got a taste in that. Got me obsessed with the rest, I got an itch to scratch. I'll give up everything.
The venom in my brain, running from the past, wanna escape my pain. I just wanna be a better person, I deserve this, I just wanna break these chains. Always asking for greatness, true to myself, I never fake it. Seen no many once, I just so they get famous. And when I say the truth, most really can't take it. In spite of everything I've been through, I'ma make it. Fake friends, but on my downfall is toxic. Day one, started to outlaws for profit. Now all I do is write verses, no talking. All I do is put the work in, no option. This was everything I ever wanted. Created a legacy off of me, just being honest. And the fake ones hate, but it's all to no avail. They wanna see me lose, but you know I never fail.
I'll give up everything, daunting if I can see my dream. 'Cause I'll do anything. Want a reality. I'll give up everything, daunting if I can see my dreams. 'Cause I'll do anything.
Hello, I hope y'all are having a great day today. So, look, I have to show y'all something. I was working on a little birthday video, in case anyone has a birthday. So, let me show y'all what I did so far. Okay, ready? It's supposed to have sound, and I can't get the sound to work, and I don't know why, but here's the video part. Did y'all like it? Y'all know y'all liked it. And what about my new background I made? Y'all, I've been doing stuff. Oh, I don't have makeup on, and y'all already know I don't give a fuck. But I have to show y'all this. Alabama Mama 4 sent me this. Y'all know she does ring bombs. It's like purple, and it has like a band like this. So I got this in the mail today from her. Thanks, Mark. So that's I wanted to show y'all, and I wanted to show y'all the birthday thing. And let's go. Where Mr. Chad Daybell trying to get the death penalty off the table. Oh no, sirree, you cannot have it. I will not allow you. I bet you Chad's shitting in his drawers right now. Thank you, Christina. So this is of course, from John Pryor's office. State April 1st, you guys. His trial starts April Fool's Day. We know that it's getting close, so now he's getting scared. So this is a motion in lemonade. A motion in lemonade is this because I didn't know, so I had to look it up. It's the Latin term in lemonade literally means on the threshold or at the start. So it says motions in lemonade ask the court to order the opposing party, its counsel, and witnesses not to talk about or even mention certain facts or evidence in the presence or hearing of the jury. If the motion is granted, nobody is allowed to bring up those facts without first obtaining permission from the court. From the courts. Court. I can't write. Thank you, Christina. Okay. State of Idaho versus Chad Daybell motion in lemonade to limit state consistent arguments on defendant's relative culpability notice of hearing. They really scared of what happened with Lori over there. Comes now the defendant, Chad Daybell, and through undersigned counsel, submits this motion in limine to limit state to consistent arguments or defendant's culpability. The core of the state's case against Mr. Daybell's co-defendant, Lori Vallow, was that she was the driving force behind a conspiracy leading to the deaths of Tylee Ryan, J.J. Vallow, and Tamara Daybell, that Mrs. Vallow used both Alex Cox and Chad Daybell through emotional and sexual manipulation, and that Ms. Vallow remained in charge of her plan throughout, because it would violate principles of fundamental fairness, due process, and the prohibition against cruel and unusual punishment to allow the state to present a different core theory in prosecuting Mr. Daybell. Mr. Daybell requests that the state be limited to presenting the same theory of its case in any trial against him, pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution. Wait, or could the state be limited to presenting the same theory? So okay. Their theory was that it was about power, sex, and money, and that she was I don't know, the state said she was the bad guy. During the trial, Ms. Vallow, the state argued repeatedly and consistently that the alleged conspiracy was set in motion by Lori Vallow and was driven by Lori's desire for and use of power, money, and sex. As the state asserted, Ms. Vallow manipulated both Chad and Alex Cox throughout the plan that she had set in motion. She manipulated Chad through emotional and sexual control. Lori uses sex to manipulate Chad, and Chad seeks confirmation from Lori repeatedly. She groomed Alex Cox. The core of the state's case was that Lori set a conspiracy in motion, that she manipulated Chad and Alex to partake in that conspiracy, and that she was in charge throughout her plan. There is one common thread through these murders, Lori Vallow. She is the one person who ties these all together. Lori is the conduit of information to Alex. He does. Alex does what Lori tells him, a plan to remove obstacles. Lori Vallow is telling Alex Cox what to do. In these messages, you never see Alex tell her what to do. She's telling him what to do. Melanie Gibb even responds, "Okay, Captain." Why does she say, "Okay, Captain"? Because Lori's in charge. More specifically, a core part of the state's case was that Lori manipulated Chad and that Chad took direction from Lori. In the state's own words, Chad is not going to act without Lori saying so. The state repeatedly argued that Chad followed Lori's lead throughout the conspiracy that Lori herself set in motion. And Chad seeks confirmation from Lori repeatedly. What does Chad say? Just grab me by the storm, and I will follow you to the ends of the universe. Not will you follow me, Lori. I will follow you. Per the state's argument and presentation of evidence, Chad Daybell would not have acted without direction from Lori Vallow. Aw, Mark, you're so sweet. Argument. Serious questions are raised when the sovereign itself takes inconsistent positions in two separate criminal proceedings against two of its citizens. See United States versus Valencia Mendoza. The United States Supreme Court has addressed the prosecutor's use of inconsistent prosecutorial theories in co-defendant cases on only one occasion, which considered whether even a guilty plea could remain valid when the state has altered its theory regarding co-defendants' relative culpability and conspiratorial roles. In Bradshaw versus Stump, the Supreme Court considered a petitioner's challenge to its guilty plea of aggravated murder and attempted aggravated murder, and more specifically, the viability of the prosecutor's use of inconsistent theories involving two co-defendants who were tried separately. Below, the United States Court of Appeals for the Sixth Circuit had held that the prosecution's use of inconsistent theories as the as to the identity of the shooter violated due process and required the invalidation of the defendant's guilty plea. On appeal, the Supreme Court held that the guilty plea itself could remain intact since the identity of the triggerman did not requisite intent for a plea. However, while expressing no opinion on whether the prosecutor's actions amounted to a due process violation or whether any such violation would have been prejudicial, the court held that the inconsistency may have influenced sentencing and thus reversed the sentence and remanded for further sentencing procedures. And more directly addressing the issue of inconsistent prosecutorial theories being presented at co-defendants' severed trials, lower courts have repeatedly held that the state may not present inconsistent theories that go to the core of their case. See Thompson versus Cauldron, overturned on other grounds, stating it is well established that when no new significant evidence comes to light, a prosecutor cannot, in order to convict two defendants at separate trials, offer inconsistent theories and facts regarding the same crimes. So they can't turn around and be like, they have to say Chad was the follower of Lori because Lori was convicted of being the leader of Chad and Alex. So when Chad goes to court, they can't say he was the leader. They have to say he was the follower, right? Is that what this is saying? Here, the core of the state's case in Lori Vallow's trial was that she was the driving force behind the alleged conspiracy leading to the deaths of Tylee Ryan, J.J. Vallow, and Tamara Daybell. That she used both Alex Cox and Chad Daybell through emotional and sexual manipulation, and that she remained in charge of her plan throughout. As such, it would plainly be inconsistent with the core of the state's case to argue in Mr. Daybell's trial that he was the person that planned or set in motion a conspiracy leading to these deaths. This plan was driven by Lori's desire for use of money, power, and sex, and this plan which she set in motion. Not no more. Now she's living off the state of Idaho and hopefully soon the state of Arizona, which, still. It would likewise be inconsistent to argue for the state to argue that Chad's alleged actions were taken of his own accord, free from manipulation and coercion. Lori manipulated Alex through religion. She manipulated Chad through emotional and sexual control. Lori uses sex to manipulate Chad, and Chad seeks confirmation from Lori repeatedly. It would be highly inconsistent for the state to argue that anybody but Lori was in charge throughout the plan that Lori set in motion. Alex does what Lori tells him. Lori Vallow is telling Alex Cox what to do. In these messages, you never see Alex tell her what to do. She's telling him what to do. Melanie Gibbs responds, "Okay, Captain." Why does she say okay, Captain? Because Lori's in charge. To remain consistent with the core of the state's case against Miss Vallow, the state must be limited to arguing that Chad followed Lori's lead. Where did hold on. I lost my spot. Chad followed Lori's leads throughout the alleged conspiracy that Lori herself set in motion. Chad is not going to act without Lori saying so, and Chad seeks confirmation from Lori repeatedly. Why does Chad say, "Just grab me by the storm and I will follow you to the ends of the universe"? Not, "Will you follow me, Lori? I will follow you." I know I didn't read this page already. Especially in a co-defendant's case where only one defendant faces the possibility of a death penalty. The relative culpability of each defendant goes to the core of the prosecution's case and directly impacts the constitutionality of a resulting sentence. Edmond versus Florida, holding that identical treatment of co-defendants without regard for their different levels of culpability were impermissible under the Eighth Amendment. Holding that in capital cases, similarly situated co-defendants should not be given arbitrarily or unreasonably disparate sentences. If the state is permitted to argue theories of relative culpability that are different from those presented during Ms. Vallow's trial and sentencing, it will violate Mrs. Daybell's due process rights under the 14th Amendment to the United States Constitution and Article 1, Section 13 of the Idaho Constitution, and may result in Mr. Daybell and his co-defendant receiving unreasonably disparate sentences in violation of the Eighth Amendment to the U.S. Constitution and Article 1, Section 8 of the Idaho Constitution. I know. Chad still is a dum-dum. Conclusion. For the foregoing reasons, the state should be limited to arguing only levels of relative culpability that are consistent with what was argued during Mrs. Vallow's trial and sentencing, especially if the state continues to seek more severe punishment of Mr. Daybell than his co-defendant. But that's not true. She had life. They messed up and they had to take it off the table. Don't be shady because they didn't mess up for you and you get it taken off the table. No. In particular, the state must be limited to presenting the same core theory that was presented in the prosecution of Mrs. Vallow, that she was the driving force behind a conspiracy leading to the deaths of Tolly Ryan, J.J. Vallow, and Tamara Daybell, that Miss Vallow used both Alex and Chad through emotional and sexual manipulation, and that Miss Vallow remained in charge of her plan throughout. Notice is hereby given that on 29th day of November 2023, at the hour of 9 a.m. or as soon thereafter as counsel may be heard, John Pryor, attorney for defendant above named, will call up for hearing a hearing for defendant's motion in limine to limit state to consistent arguments regarding culpability before the Honorable Judge Stephen W. Boyce, District Judge at the Fremont County Courthouse in St. Anthony, Idaho. Signed the 9th day. Signed John Pryor. John Pryor. Lord, y'all, now I see why he was up in Lori's trial every day, why he had the transcripts, why he had the video, why he had everything because he was literally taking that thing piece by piece. His kids are on his side, unfortunately. I'm sorry, I'm just taking a quick break to vape and to drink because this is a lot to read. This one is 8 pages, and then the last one is 11 pages. I hope everyone is having a good day. Sorry, hold on one second. Let me see here. Don't go anywhere. Cool, thanks. My pipe's been lost for 24 hours and it was just found. But anyway, look how it has like the levels of the battery and the juice. It's really cool. But it tastes like shit. Shit. Gross. All right, let's go. Y'all hit that like button for me because this is hard to read, people. John Pryor's office once again. A state of Idaho versus Chad Daybell. Motion to strike the death penalty as arbitrary, capricious, and disproportionate in light of striking death in co-defendant's case. He hooked up with her for a small time now. Comes now the defendant, Chad Daybell, and through undersigned counsel, submits this motion to strike the death penalty as arbitrary, capricious, and disproportionate in light of striking death in co-defendant's case, pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution and the Idaho Constitution, Article 1, Section 6, 7, 8, and 13, as well as the legal authorities cited below. Mr. Daybell respectfully requests that the court strike the death penalty as a sentencing option to avoid a situation where the severity of punishment turns on a co-defendant's decision whether or not to waive speedy trial rights, as opposed to their relative levels of culpability, in violation of fundamental constitutional rights and judicial fairness. But she had the death penalty on the table to begin with. It was taken off because the prosecution messed up. I don't think they should just take yours off the table because they didn't mess up on your stuff. You still deserve it. Factual and procedural backgrounds. The state of Idaho has charged Chad Daybell and Lori Vallow as co-defendants in connection with the deaths of Tylee Ryan, J.J. Vallow, and Tamara Douglas Daybell on August 5th, 2021 and May 2nd, 2022. The state filed its notice of intent to seek death penalty against Mr. Daybell and Ms. Vallow, respectfully. On August 19th, 2021, Mr. Daybell waived his right to a speedy trial. On March 3rd, 2023, the court severed Mr. Daybell's and Ms. Vallow's trials. On March 21st, 2023, the court struck the state's May 2nd, 2022 notice of intent to seek the death penalty against Ms. Vallow. From the bench, the court stated that striking death was an appropriate discovery sanction and was necessary to ensure that the constitutional rights of Ms. Vallow was protected. The court did not extend the decision to Mr. Daybell, even though the state had committed the same discovery violations. Even though the state committed the same discovery violations against Mr. Daybell, well, then prior, why didn't you put in for it to be taken down, just like they did? Oh, it's because he waived his right to a speedy trial. Since he had waived his speedy trial rights. As such, the court has permitted the continued pursuit of only one co-defendant's death suit due solely to that defendant's waiver of speedy trial rights. So they're saying that they only left the death on the table because he waived his rights to a speedy trial. Hey, Kaz. Mark, we all know that, but I mean, come on. He's over there pooping in his panties. Because you know, Shy wears panties. Argument. The fundamental respect for humanity underlying the Eighth Amendment's prohibition against cruel and unusual punishment gives rise to a special need for reliability and the determination that death is the appropriate punishment in any capital case, Johnson versus Mississippi. Additionally, the United States Supreme Court has held that the Eighth Amendment demands that the death penalty, as the most severe punishment, must be limited to those offenders who commit a narrow category of the most serious crimes and whose extreme culpability makes them the most deserving of executions. I think they did. There must be a meaningful basis for distinguishing the few cases in which the death penalty is imposed from the many cases in which it is not. Gregg versus Virginia, quoting Furman versus Georgia. Amongst the entire class of murderers, the death penalty must be reserved for the worst of the worst. Okay, that's 3 deaths. Possibly, well, 3 deaths for you. Who knows with the other one? And go ahead, I'm listening. The worst of the worst you are, Chad Daybell. While every murder is appalling, the average murderer is insufficiently capable to justify the most extreme sanction available to the state. Atkins versus Virginia. Though the state has wide latitude under the Eighth Amendment to seek severe non death sentences in all other criminal cases, the Eighth Amendment's special constraints on the death penalty must be enforced by this court. In this case, there's a single distinguishing feature that explains why the state continues to seek the death penalty against Mr. Daybell, even after it was struck against Miss Vallow. Mr. Daybell waived his right to a speedy trial. Willingness to waive speedy trial rights cannot constitutionally be the deciding factor in who lives and who dies. See People versus Kleiner. Holding that in stake in capital cases, similarly situated co-defendants should not be given arbitrarily or unreasonably disparate sentences. That was a whole typo that I could not even figure out myself. When a co-defendant or co-conspirator is equally as culpable or more culpable than the defendant, disparate treatment of the co-defendant may render the defendant's punishment disproportionate. The willingness to waive speedy trial rights does not correspond to the defendant's most culpable and deserving of death, and therefore it is unconstitutionally arbitrary under Furman and Gregg for this willingness to waive to determine which co-defendant remains eligible for the death penalty. The prosecution cannot continue to seek Mr. Daybell's execution solely because he waived his speedy trial rights, while his co-defendant did not. It would be at odds with the reality of the criminal justice system and would establish dangerous precedent regarding how to advise clients in co-defendant cases to suggest that Mr. Daybell should face a far more severe punishment than his co defendant simply because he waived constitutional rights. 1. It is unconstitutionally arbitrary and capricious to continue seeking Mr. Daybell's death. Alex Mayer thinks she was more than what she was. I must be the only guy that didn't think that. I know, right? But you never know. Given that the death penalty must be reserved only for the worst of the worst, the pursuit of a death sentence must be based on the relative culpability of a person accused of murder and cannot be based on arbitrary or capricious factors outside of a defendant's own alleged offenses and characteristics. See Chapman versus the United States, holding that due process prohibits the imposition of punishment based on arbitrary distinction. The government violates a defendant's right to due process under the Fifth Amendment to the United States Constitution when its decision to seek the death penalty is arbitrary and capricious. Striking death as a potential sentencing option after finding that the government's decision to seek the penalty was arbitrary when compared to co-defendants. Ultimately, to comport with a criminal defendant's due process rights and to avoid violating the right to be free from cruel and unusual punishment, the death penalty may only be sought in a way that can rationally distinguish between those individuals for whom death is an appropriate sanction and those for whom it is not. Sapiziano versus Florida. Um, I still think he needs death penalty. I don't know about you guys. Like, I don't understand all this. I mean, I understand it, but I don't understand what, the defense has to try every single thing they can before trial. Just, if you're so innocent, why you got to try 50 million things? Earlier, I was thinking about Brian Kohlberger. If you're so innocent, why your lawyers got to try every single thing under the sun? You're innocent, you're innocent. You don't have to try 20 things, in my opinion. I don't know. They just. Mm. Oh, he did. Oh, he did. The legitimacy of our entire system of capital punishment is premised on the notion that the death penalty must be imposed fairly and with reasonable consistency, or not at all. Gregg versus Furman. Furman mandates that where discretion is afforded a sentencing body on a matter so grave as the determination of whether a human life should be taken or spared, that discretion must be suitably directed and limited so as to minimize the risk of wholly arbitrary and capricious actions, as Justice Stewart opened in Gregg. Indeed, the death sentences examined by the court in Furman were cruel and unusual in the same way that being struck by lightning is cruel and unusual. For all of the people convicted of capital crimes, many just as reprehensible as these, the petitioners in Furman were among a capriciously, am I saying that right, selected random handful upon whom the sentence of death has in fact been imposed. The Eighth and 14th Amendments cannot tolerate the infliction of a sentence of death under legal systems that permit this unique penalty to be so wantonly and so freakishly imposed. Just as the decision of who lives and dies cannot rest on chance, it also cannot turn on the rights asserted or waived by a criminal defendant during prosecution. No, the decision of who lives and dies cannot rest on chance, nor can it rest on the decision of Chad and Lori Daybell. Now what? Don't try to save your life because y'all took lives. Just because she didn't get death, don't try to back down now, asshole. You did it. You're gonna go down. And I swear, I hope to God they do not take this death penalty off the table. You need to go right where your wife is. And I'm not talking about this legal wife thing you have going on now. Just at the, yeah, I read that. In United States versus Jackson, the Supreme Court examined and struck down the Federal Kidnapping Act, which prohibited the death penalties for defendants who acceded to a bench trial and abandoned their right to contest their guilt before a jury, but authorized death where defendant proceeded to jury trial. The court reson- The court reasoned that the goal of limiting the death penalty to cases in which a jury recommends it is entirely legitimate one, but that goal can be achieved without penalizing those defendants who plead not guilty and demand jury trial. In a similar way, it was a legitimate aim of this court to ensure that Ms. Vallow did not face a death penalty based on incomplete or late discovery, but that goal does not permit authorizing differential punishments. Okay, maybe if they actually did the same exact thing to Chad that they did to Lori to get the death penalty off the table, then okay, I agree. It is what it is. They do have rights, you know, whether we want to like it or not. You know what I mean? But if that was to happen, just like on Lori, we just know that he'll get life and he'll spend the rest of his life. I mean, it's not right, of course, that JJ, Tylee, and Tamara couldn't, live out the rest of their lives because of these two people and even Alex, who is gone. But if they can't get deaths, then the best thing would be life. If they have to take it off the table because of what happened with Lori and taking it off the table with her, I don't know why it took uh prior so long. If this was really true, why didn't he do this a long time ago when they did it? No, judges have a shit ton of cases already. They have, and plus they have motion after motion after motion. Look how many years and documents filed and motions we went through and hearings and all this before Lori went to trial. Then we had to wait because Lori was incompetent for a year. Chad, Chad's just a straggler. You're right. Lori was the leader. Chad cannot be a leader. I don't Chad. I can't see Chad being a leader at all. I see him on all fours with Lori pulling him behind her with like a little leash or something. Hey, Tina. Yeah, right. But don't they have to be lawyers first? Don't judges have to be attorneys first? The sole distinguishing feature between the penalty being sought in this case and Mr. Daybell's co-defendant's case is that Mr. Daybell waived his speedy trial rights. Not because Mr. Daybell. Are you serious right now, Penelope? I don't think so. Not because Mr. Daybell is more culpable or somehow deemed more deserving of the death penalty, only because Mr. Daybell waived his speedy trial rights and thus permitted the state greater time to comply with its discovery obligations. Oh. So that's fair. Only because Mr. Daybell waived his speedy trial rights, thus permitted the state greater time to comply with its discovery obligations. That's why he's still doing the death penalty. Lori Vallow didn't waive her rights, went to trial earlier, taken off the death penalty because they didn't have enough time to turn it in or whatever, comply with discovery obligations. However, they were able to do so with Chad's because that don't mean nothing. No, that don't mean it's violated, and that don't mean that they can take the Boy, you get a death penalty. Bye bye. See you tomorrow. Number two, permitting more severe punishment because the defendant waived his speedy trial rights raises additional constitutional concerns. Judges are never attorneys. Okay, in my opinion, he did not get the death penalty staying on because he didn't waive his rights to a speedy trial. She didn't get it taken off because she didn't waive her rights. It's one or the other. You want life in prison or death. You want to go early or you want to go late. You made up your mind. You wanted to go after. You're going after. Just deal with what you got coming and just wait till April 1st and then deal with what you got. That's all you could do, Chad. You shouldn't have killed these innocent people. I don't care what. They were in your ever loving, I don't want to curse, backyard. Remember that raccoon you killed in the day? Remember that? Yeah. Remember all that, right? Death. If Mr. Daybell had not waived his speedy trial rights, he would not be facing the death penalty. He was not advised of this potential outcome at the time of his waiver, and this raises many issues. Both the Sixth Amendment to the United States Constitution and Article 113 of the Idaho Constitution guarantee to criminal defendants the right to a speedy trial. The speedy trial guarantees are designed to minimize the possibility of lengthy imposed on an accused while released on bail and to shorten the disruption of life caused by arrest and the presence of unresolved criminal charges. Right. Oh. Judges don't get paid good. While defendants have constitutional speedy trial rights, these constitutional rights can be waived. A waiver is a voluntary relinquishment or abandonment of a known right or privilege, and courts should indulge every reasonable presumption against waiver. When Mr. Chad Daybell waived his right to speedy trial on August 19, 2021, he did not know that it may lead to a situation where he would, solely on the basis of this asserted right, face far more severe punishment than his co defendant. As such, if this court does not strike death in this case to ensure reasonably equal treatment of the co defendants under the law, then Mr. Daybell's initial waiver will be called into question, since he was not advised of this potential and significant consequence. Even if an appellate court determined that his initial waiver was made knowingly, he would have a strong argument that he was provided ineffective assistance of counsel under the Sixth Amendment and Article 1, Section 13 of the Idaho Constitution, since he was never advised of this possibility. Okay, so they were both being tried together, both with the death penalty, right? Then Lori went, didn't waive rights to speedy trial. They were getting things underway for her trial. Things weren't turned in from the discovery on time. So they put in a motion for the state to take off the death penalty. So now Chad thinks that it's not fair. It's not fair to Chad that they took the death penalty off of Lori's case. Life's not fair, Chad. It's not fair that JJ, Tylee, and Tamara can't live anymore. Is that fair? What's fair, Chad? You want to talk about fair? For the foregoing reasons, Mr. Daybell respectfully requests that this court strikes the state's August 5th, 2021 notice of intent to seek the death penalty pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution, Idaho Constitution, Article 1, Section 6, 7, 8, and 13. In doing so, the court will ensure the decisions of whether defendants should live or die do not turn on whether they have waived or asserted speedy trial rights, but rather are rooted only in relative levels of culpability and personal characteristics. Notice is given the 29th day of November, 9 a.m. John Pryor will call for a hearing on the defendant's motion to strike the death penalty. Judge Stephen Boyce. And that's that one. Huh. Let me let her out before she starts screaming at y'all like she usually does and make y'all think I beat on my baby. Hold on. Come on. Come on, baby. Come on, Mama. Ooh, something smells good. Okay, I'm back. At first, I thought you said cocky family, but you said kooky family. John Pryor's office. State of Idaho versus Chad Daybell. Motion to strike the death penalty based on relative culpability. I know, right? Comes now the defendant, Chad Daybell, and through undersigned counsel, submits this motion to strike the death penalty based on relative culpability. During the trial of Mr. Daybell's co-defendant, Lori Vallow, the state consistently argued that Ms. Vallow was the most culpable party to the alleged conspiracy that led to the deaths of Tylee Ryan, J.J. Vallow, and Tamara Daybell. As the state repeatedly argued, Ms. Vallow set the conspiracy in motion. She manipulated both Alex Cox and Chad Daybell, and she remained in charge of her plan throughout. As the state plainly put it, Lori manipulated Chad through emotional and sexual control, and Chad was not going to act without Lori saying so. I'm pretty sure this says the same thing as the other. Hey, Queen Olive, I hadn't seen you. Um, Chad is nuts. If he wanted to be treated like Lori, he should have kept his child with hers, right? That's what I say too. There's like, yeah, now they want to be treated this. He wants to be treated the same. As such, per the state's own presentation of evidence and arguments in the trial of Lori Vallow, Mr. Daybell has lesser culpability than his co-defendant, who did not face a death penalty. Even when two co-defendants are equally culpable, it is unconstitutional and unacceptable to subject one of them to the most extreme punishment available, while the other did not face that possibility. Therefore, Mr. Daybell should not face more extreme punishment than the co-defendant that the state itself has alleged to be more culpable. Pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution, Idaho Constitution Article 1, Section 6, 7, 8, and 13, as well as the legal authorities cited below, Mr. Daybell respectfully requests that the court strike the death penalty as a sentencing option so that Mr. Daybell faces a maximum punishment in line with the co-defendant alleged to be more culpable. Yep. You just lurk, girl. You lurk. You got this. This one is a little bit longer, guys, so just bear with me. We'll be okay. Factual and procedural background. The state of Idaho charged Chad Daybell and Lori Vallow as co-defendants in connection with the deaths of Tylee Ryan, J.J. Vallow, and Tamara Douglas Daybell. On March 3rd, 2023, the court severed Mr. Daybell and Ms. Vallow's trials. Ms. Vallow's trial began in April 2023. She was convicted on all counts and ultimately sentenced to life in prison. During her trial, the state argued that Ms. Vallow was the most culpable party to the alleged conspiracy in the following ways. Lori Vallow was the common thread between the murders and set the alleged conspiracy in motion. And this is just excerpts from Lori's trial. This plan was driven by Lori's desire for and use of money, power, and sex, and this plan which she set in motion. And there's one common thread through these murders, Lori Vallow. She is the one person who ties these all together. She's moving this plan forward. There is no question that Tylee Ryan, J.J. Vallow, and Tammy Daybell was murdered. Who is the common thread? Lori Vallow. The evidence in this case points to one common thread, and that thread is Lori Vallow. She is a killer. Lori is the connection to the deaths. Number two, Lori Vallow manipulated Alex Cox and Chad Daybell to follow her. Lori manipulated Alex through religion. She manipulated Chad through emotional and sexual control. She groomed Alex Cox. Lori uses sex to manipulate Chad. Chad seeks confirmation from Lori repeatedly. Chad's telling Lori what she wants to hear. She reinforces him with sexual behavior. Lori Vallow led the alleged conspiracy throughout. That was number three. Chad is not going to act without Chad is not going to act with Lori saying so. So let's say Chad is not going to act without Lori saying so. Chad is not going to act with Lori saying so. Don't act, Chad. Lori says don't. Don't do it. Then you won't get the death penalty because Lori didn't say do it. I don't know, Mark Klein. There's been, hey, I got my ring today. Let me show you. I showed earlier. I showed everybody earlier. Where is it? Oh, I showed everybody earlier when I first came on. I love it. Thank you. Thank you very much. Um, Lori is the conduit of information to Alex. Alex does what Lori tells him. Lori Vallow handed off JJ and Alex Cox to Alex Cox. Lori Vallow is telling Alex what to do. In these messages, you never see Alex tell her what to do. She's telling him what to do. Melanie Gibb responds, okay, Captain. Why does she say, okay, Captain? Because Lori's in charge. What does Chad say? Just grab me by the storm and I will follow you to the ends of the universe. What do you call the storm, Chad? Not will you follow me, Lori. I will follow you. Because he's a little PU $, why? The Philippines girl? Who's the Philippines girl? From this case? Okay. In sum, the consistent core of the state's case has been that Lori set a conspiracy in motion, that she manipulated Chad and Alex to partake in that conspiracy, and that she was in charge throughout her plan. Based on the state's presentation of evidence and arguments, Ms. Vallow was convicted on all counts, but she did not face a death penalty. Only Mr. Daybell, who the state has asserted was not going to act without Lori saying so, is facing the death penalty. Despite the state repeatedly asserting that Lori Vallow sexually and emotionally manipulated Chad Daybell in pursuit of her aims, Mr. Daybell faces a more severe punishment than Mrs. Vallow, despite the state's consistent argument that Lori groomed Alex Cox, continued to manipulate him, then handed her son off to be killed by Alex. Only Chad faces the death penalty. Despite the state's presentation of evidence that Chad will follow Lori, not the other way around, only the person alleged to be the manipulated follower is facing the possibility of death. Melanie Boudreaux and Pulowski. The United States and Idaho constitutions both prohibit cruel and unusual punishments. United States Constitution Amendment 8, Idaho Constitution Article 1(6). Under each punishment is cruel and unusual if it is excessive in relation to either the circumstances and nature of the crime itself or the personal characteristics of the offender. C. Graham versus Florida. The concept of proportionality is central to the English is oh my God, is central to the Eighth Amendment. Roper versus Simmons. Recognizing that the Eighth Amendment's respect for the dignity of all persons include a requirement that punishment be proportionate to the offense and offender. Put differently, a sentence is constitutional only when it is proportionate both to the facts of the crime and the offender's relative culpability. Given the uniquely harsh nature of the sentence, capital punishment must be limited to those offenders whose extreme culpability makes them the most deserving of execution. Quoting Atkins versus Virginia, a crime may be one that inflicted hurt and horror on the victim and that caused revulsion in society and the jury that represents it, but may nevertheless be one for which death is a disproportionate penalty. Kennedy versus Louisiana. Thus, regardless of the morally shocking nature of an alleged offense, the death penalty may be a disproportionate sentence based on the offender's relative culpability. With respect to this proportionality inquiry, in co-defendants' cases, evaluation of each individual's relative culpability in the same criminal case is a necessary element of a constitutional death sentencing scheme. My eyes are blurry and all these words are coming together. Sorry. When two co-defendants have the same level of alleged culpability, it is unconstitutionally cruel and unusual to sentence one to death while the other does not receive such a sentence. When a co-defendant or co-conspirator is equally as culpable or more culpable than the defendant, disparate treatment of the co-defendant may render the defendant's punishment disproportionate. Numerous state courts have recognized the constitutional necessity of case-specific proportion. I cannot say this word now or tomorrow or yesterday or forever. Between co-defendants in capital cases. Smith versus Commonwealth. The trial court precluded the death penalty as a possible sentencing option for one co-defendant after a more culpable co-defendant pled and received a term of years. The Kentucky Supreme Court upheld this ruling. In Slater versus State, two men were charged with murder of a motel manager during a robbery. The co-defendant who pulled the trigger pled to first-degree murder and was sentenced to life. The other co-defendant who fully participated in planning and executing the robbery but did not pull the trigger went to trial and was sentenced to death. In recognizing the inherent unfairness of this outcome, the Florida Supreme Court reduced this death sentence to life in prison. We pride ourselves in a system of justice that requires equality before the law. Defendants should not be treated differently upon the same or similar facts. When the facts are the same, the law should be the same. The imposition of the death sentence in this case is clearly not equal justice under the law. We recognize the validity of the Florida death penalty statute, but it is our opinion that the imposition of the death penalty under the facts of this case would be an unconstitutional application under Furman versus Georgia. Similarly, in Hazen versus State, the court reversed the death sentence imposed against Mr. Hazen, one of three co-defendants involved in a burglary, rape, and murder. Three men entered the house of a couple, shot a man at point-blank range, killing him, and took turns raping his wife. One of the non-Sugarman co-defendants received a sentence of life in exchange for testifying against the other two. Mr. Hazen, the other Sugarman, was sentenced to death at trial. In reversing the sentence, the court found it was disproportionate to sentence Mr. Hazen to death, given that he was less culpable than the non-Sugarman co-defendant who had cut a deal. Well, Lori didn't kill them. Who killed them? Chad? Did you only bury them? What the hell? Who shot the raccoon? Chad? One moment, please. I just need a sip of drink. Can Lori testify against Chad? It said it was the non-triggerman co-defendant who had cut the deal and testified against him. The state asserted that it wished to sentence all three co-defendants to death, but made a strategic decision to offer one of the non-triggermen a deal in order to strengthen their case against the other two. Well, again, don't be mad because they choose the other one and not you. You did the crime. The court concluded this was not an adequate justification to depart from the principle that justice requires equality before the law. The court then reaffirmed that a life sentence for one defendant precludes a death sentence for a less culpable co-defendant. In Hall v. State, 1978, overturned on other grounds, the defendant was sentenced to death for the armed robbery and felony murder of a liquor store clerk. His co-defendant, the triggerman, received a life sentence. In finding that there was no evidence Hall was the prime mover in the crime, Hall's death sentence was vacated. Under these circumstances, the death sentence imposed upon Hall for the same crime in which the co-defendant triggerman received the life sentence is disproportionate. Other cases have iterated this same principle. Curtis versus State, reducing death sentence to life without possibility of parole after 25 years, where co-defendant was the actual killer and sentenced to life. You can't say that. She wasn't convicted of killing them. And anyway, you have a whole murder charge on you with your wife. So take the death penalty for that. Now what? Ugh. This don't have nothing to do with you. What did Chad? Oh, yeah. Despite the core of the state's case against Mrs. Vallow centering around her heightened culpability, her manipulation of Mr. Daybell, and her directing of the alleged conspiracy, only Mr. Daybell faces the death penalty. While the state's prosecution of Miss Vallow has established that, even if all of the state's allegations were accepted as true, Mr. Daybell was not more culpable in the alleged conspiracy than Mrs. Vallow. He did this shit on purpose. Y'all, he did this shit to do this on purpose so that she could go to trial first so that he could do this right behind her. Be like, oh, she did it. She's serving life. She was found guilty. It was not me. I don't want the death penalty. She did it. Not me. She killed them. Said no one ever. Additionally, as other cases have pointed out, it is arbitrary and capricious in violation of Mr. Daybell's due process rights to continue seeking the death penalty against him when a more culpable co-defendant has been spared that outcome. Multiple members of the Aryan Brotherhood were put on trial for a series of murders committed at the behest of the organization when two leaders. See, this is not nothing to do with what y'all are doing. After all that stuff that doesn't even matter, anything to do with Chad or Lori's situation, the court struck the death penalty on that story. For the foregoing reasons, any death sentence imposed upon Daybell would violate the fundamental constitutional principles requiring equal justice under law and would be unconstitutionally disproportionate, excessive, fundamentally unfair. Life is not fair. And it's not fair that they're not able to breathe another breath of air in this world. Why? Chad, why? It's not fair to them. Screw you. But I can't deal with him. Mr. Daybell respectfully requests that this court strike the state's August 5th, 2021 notice of intent to seek the death penalty pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution, Idaho Constitution, Article 1, Section 6, 7, 8, and 13. Thanks, Alabama Mama, for you're so sweet. And then 9 a.m. or sooner on the 29th day of November 23rd, John Pryor will call up for a hearing for the defense motion to strike death penalty. And we can't wait for that because I so want them to shove it in his face that wham bam, thank you, ma'am, you're getting the death penalty. And hopefully they'll shoot you with the firing squad. They have the firing squad now, right? If anybody, like if he was to get convicted next year, well, yeah, April of next year, then he can, if he gets death, he can get the firing squad, right? Yeah, I think so. Thank you, Queen Olive. Y'all are so sweet. I don't know where everybody's at today, but I don't see no green in this chat. There is no green or blue. Where is everybody at? Holy shit. There's literally no. Where are y'all at? Oh no. Mm-mm-mm. Nope. Because December 2nd is my birthday and I need $45 more in order to get a check December 21st. So I will be getting one for my birthday. Hey, Joe. There you are, Kaz. Oh. By the time they do him in Death, he won't be around. I know, right? Thank you, Queen Olive. Yay, we got some green in here. Where's all my green? I'm going to unmod people so that they're green, not blue. You guys be safe in your plans today. For all Aussie true crime's not here either. Dang. And I was like, yay. No, I had to come live late because I had a chiropractor appointment at 2 when I usually go live. So I had to go late. And then I was like, oh, good. Nobody's live. So then, like, everybody likes Chad Daybell. And then nobody was coming in. And I'm like, what the hey? What the hey ho? Hey ho. All right, y'all. Y'all have a good night. I was going to do some serial killer stuff, but I decided not to. So instead, I'm going to thank you so much, Queen Olive Ruthann. I appreciate that so very, very much. Samuel, what the hell is his last name? Y'all know that dude, Samuel. What the hell is his last name? Haskell. Samuel Haskell. The one they found the torso by his house in a dumpster. A homeless guy found it and he was arrested. And it turns out his wife and his in-laws are missing. So they're thinking that the torso may be his wife. And the in-laws that are still missing possibly met the same fate as his wife. I'll be going over that tomorrow. So that's interesting, guys. We'll see what happens with that. Also, trivia. Trivia will be back starting Sundays. Guys, share, share, share. Trivia is fun. Kaz says, sweet, I miss my trivia. Okay, Kaz, you're going to have your trivia back on Sundays. Yes, I know. You heard of it, Alabama Mama 4? I don't know. I don't know. All right, guys. Y'all have a wonderful night. All my Aussie friends. Yeah. Why are you laughing, Mark? I know you better be here, right? You're going to be here, right? Sunday trivia. Be here or be square. Is that how it goes? She got 260 million. Oh, wonderful. It'll never, ever, ever fix what she had to go through and what her mom went through and what she has to go through without her mom. It'll never fix all of that. But um thank you, Alabama Mama, for I appreciate that. I am so, so happy. 260 million. Yeah, that sounds like a Powerball figure or something, right? So happy for her and that it's all. Oh, okay. Yes, Trivia Sunday. Don't forget. The notification is out already if you want to share it. It is fun. That is so awesome. Wow. Well, I'm glad that's all over with for her and that she can just go on with the rest of her life. You know, it's so sad. It's so sad that people have to go through that. I don't know. I know. I think I heard you tell me that. So they just need to close that hospital down. It's John Hopkins, right? Hmm. I don't know. So Chad's is April of 2024. And the next one is December 15th, I think it was, we said. Um, yeah, December 19th, Courtney Clenny. Yeah, John Hopkins. Um, Dang, they do a lot of good for a lot of people. And I guess two or three out of a million aren't bad. Am I wrong for thinking that? I mean, I know it's horrible what happens, but malpractice is a thing. Things happen like doctors aren't perfect. Look what they did to my nanny, you know. I don't know, it's just weird. But I don't know the case, so I'm not going into it because I don't want to go into it. Oh, really? I don't think they will close down. They have money. They have a lot of money. All right, guys, y'all have a good night. I will see you else somewheres on these YouTube streets, but not here until tomorrow. Bye, everyone.